Article 2.5 of the Constitution of Kenya provides that the general rules of international law shall form part of the law of Kenya. Article 2.6 provides that any treaty or convention ratified by Kenya shall form part of the law of Kenya under this particular constitution. So I want us to analyze the impact of globalization on lawmaking in Kenya. You see, globalization refers to the increasing interconnectedness of state through trade, through technology, through migration, through diplomacy, through human rights systems, and international governance. In legal terms, globalization has transformed, how national laws are made, how they are interpreted, and how they are enforced. The Constitution of Kenya 2010 constitutionalized this reality under Article 2.5 and 2.6 by incorporating general rules of international law and ratified treaties into the Kenyan law. And this marked, a major shift from Kenyan's older dualist model towards, a hybrid model where international law directly influences, domestic law. Article 2 of the Constitution of Kenya expressly makes international law and ratified treaties part of Kenyan law, and this is subject to constitutional supremacy. Now, the impact of globalization on lawmaking in Kenya has been both transformative and controversial. So, what is the meaning of globalization in lawmaking? You see, legal globalization means that international norms influence domestic legislation. Treaties, shape national legal obligations, foreign jurisprudence influence courts, and international institutions, affect legal reform. Now, before 2010, international treaties often required legislative domestication. But after 2010, ratified treaties, formed part of Kenyan law, and these significantly expanded global influence. Now, what is the positive impact of globalization on lawmaking in Kenya? The first impact of globalization on lawmaking in Kenya is the expansion of human rights law. You see, globalization has strengthened right-based type of legislation. Kenya increasingly aligns domestic law with international human rights standards. And examples are, the United Nations Human Rights Convention, African Union of Human Rights Instruments, and the Convention on the Elimination of all forms of discrimination against women. Now, these instruments, shape Kenyan laws on gender equality, on children's rights, and on anti-discrimination. If you look at the case of Rono versus Rono, this case involved, inheritance dispute involving gender discrimination. And the issue was whether daughters could inherit property. And the rule is that equality principles informed by constitutional and international law applies. And the application of this particular case was that the court relied on international non-discrimination principles, so that the conclusion of this case was that equal inheritance was actually upheld. Now, the impact of this case is that global human rights norms influenced, domestic justice in Kenya. The second impact of globalization on lawmaking in Kenya is gender law reform. You see, global legal standards influenced, affirmative action. They influenced anti-GBV laws, and they also influenced equality laws. The Constitution reflects international gender norms, especially equality and representation, so that Kenya's gender equality framework reflects international treaty obligations, especially under Convention on the Elimination of all forms of discrimination against women, CEDAW. Now, if you look at the case of Crew versus Attorney General, the court emphasized constitutional gender obligations, and this reflects, international equality standards. The third impact of globalization on lawmaking in Kenya is environmental law development. You see, global environment treaties have shaped Kenyan law. Examples include, the Paris Agreement and Kyoto Protocol. These influenced, Kenyan environmental legislation. In fact, globalization made environmental law stronger in Kenya. If you look at the case of Save Lamu versus National Environmental Management Authority, the facts of this case, involved, challenge, against environmental approvals. And the issue was whether environmental rights were violated. And the rule is that environmental rights and sustainable development are paramount. And the application of this case was that the court emphasized environmental justice. And the conclusion was that environmental governance was strengthened. You see, the impact of this particular case is that global environmental principles, entered, the local law. Now, I want us to look at economic globalization and lawmaking. Now, the first thing to consider under economic globalization and lawmaking is commercial law harmonization. You see, global trade requires legal uniformity. In fact, Kenya has aligned laws with international trade standards, with investment, treaties, and also regional trade systems. Examples are, the World Trade Organization and the East African Community. This improves, business certainty. The second thing to consider under economic globalization and lawmaking is intellectual property law. You see, globalization has expanded intellectual property regulation. In fact, Kenya follows, international IP standards, and examples include, patents, trademarks, and copyright. These are driven, by international convention. If you look at the case of Phonographic Performance Limited versus Attorney General, this case, shows international, copyright influence. Now, let's look at judicial globalization. You see, Kenyan courts increasingly rely on comparative jurisprudence, so that courts cite decisions from South Africa, they cite decisions from India, United Kingdom, and even Canada and the United States. You see, this enriches, constitutional interpretation. If you look at the case of Me Too Bell Welfare Society versus Kenya Airports Authority, courts used, comparative human right type of reasoning. This reflects, global judicial dialogue. Now, what about, regional integration and legal reform? You see, globalization is not only international, but it is also regional. Kenya's membership in the East African community has influenced, custom law, it has influenced trade law, and it has also influenced migration law, so that regional treaties influence legislation. Now, let's look at the negative effects of globalization on Kenyan lawmaking. The first negative effect of globalization on Kenyan lawmaking is the erosion of parliamentary sovereignty. You see, critics argue that international law weakens domestic democratic control, in that treaties may influence law without direct public participation. So that before 2010, Parliament had stronger domestic control, but after 2010, international commitments, affect domestic legal outcomes, and this raises, legitimacy concerns. Scholars note that Article 2.6 altered, the traditional domestication model and expanded treaty influence in domestic lawmaking. The second negative effect of globalization on Kenyan lawmaking is cultural conflict. Some international norms, conflict with local culture. Example include, inheritance norms, family law, and reproductive rights, so that global human rights standards may clash with customary systems. If you look at the case of Otieno versus Ougo, there was a conflict between customary norms and modern legal principles. And this case shows, tension between local and global norms. The third negative effect of globalization on Kenyan lawmaking is legal dependency, in that over-reliance on foreign legal models may weaken local legal identity, so that Kenya may adopt laws unsuitable for local realities. Examples, include imported governance models without local adaptation. Now, what is the relationship between globalization and criminal law? You see, international criminal norms influence Kenya. And examples include anti-terror laws, anti-money laundering laws, and anti-traffic laws, which are driven, by international obligation. If you look at the case of Coalition for Reform and Democracy, Court versus Republic, there was a challenge to security laws, balancing rights and international security obligation. And this case shows, global security law influence. So what is the constitutional position? Does supremacy still matter? You see, globalization does not override the Constitution. Article 2.1 makes the Constitution of Kenya 2010 supreme, in that international law applies only within constitutional limits. In fact, Kenyan courts have affirmed that international law forms part of Kenyan law, but remains subject to constitutional supremacy and local statutory coherence. Hence, globalization influences law, but the constitution controls globalization. So the fact is, globalization, has transformed Kenyan lawmaking in terms of positive, and negative impact. And the positive impact is we have had stronger human right protection, but the negative impact is reduced, legislative autonomy. The positive impact is better trade regulation, but the negative impact is cultural conflict. The positive impact is stronger environmental law, but the negative impact is foreign legal dependency. The positive impact is better judicial development, but the negative impact is democratic legitimacy concerns. So that globalization is neither wholly beneficial or entirely harmful. The effectiveness of globalization, depends on constitutional management. So the conclusion is that Article 2.5 and 2.6 constitutionalize globalization in Kenyan law by incorporating international law and treaties into the domestic legal system. Globalization, in fact, has positively transformed Kenyan lawmaking through human rights expansion, through gender equality, through environmental protection, through trade regulations, and also through judicial innovation. However, it has also raised concerns about sovereignty, about democratic legitimacy, and about cultural autonomy. And the proper approach is balanced, constitutional kind of globalization. That is embracing, useful international norms while preserving constitutional supremacy and also Kenyan, social realities. My name is Biketi. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.